or not, my reading of the evidence or speaking notes were received pre-circulated from Ngāti Rahiri is mostly related to the noise provisions for the multi-purpose zone and not so much in terms of the airport, but they may wish to, well, I expect they will clarify that tomorrow. But that's the only procedural issue I could see in terms of that supplementary evidence.
And we can have a talk with Keith now about that. But before you go, Mr. Weasney, there are no other parties associated with this apart from Ngāti Rahiri, as far as you're aware?
The second party in terms of a further submitter is Hardwick Smith Partners, but they, I haven't seen that they've registered interest to appear at the hearing.
Okay, no, Julie's shaking her head. And just do you see any utility or merit in perhaps having some further discussions with the council experts from a council point of view by way of a focus witness conference?
Yes, no, I support that proposition. I think I'm familiar with that in terms of another hearing had with before you last year, where it was an effective process for similar reasons that we're dealing with now. So no, I support that proposition.
All right, so just we'll hear from Mr. Holswich now, and then we can decide just some planning around that.
Thank you, Mr. Chairman. Our initial comment was about the noise and how it was to be dealt with. At the moment, after listening to all the experts, I must admit that my head is rather scrambled at the moment. It was way above my level of expertise. I'm happy for us to withdraw any comments we had regarding the airport. It's outside our rohe. We were just making general comments. I think we'll put that aside at the moment, if that's okay with you.
No, that's fine, and appreciate that. That sounds a pragmatic approach.
Thank you, Mr. Chairman.
All right, well then, I'll leave you, Ms. Ongley, to organise with the council team. They certainly through Ms. Straka and yourselves about a proposal for a witness conferencing process. I think while we've perhaps got the thoughts in our mind, I'm thinking if that could be done within the next two or 3 weeks, that would be helpful.
Yes, sure. So would Commissioner, would that be between Mr. Weasney and Mr. Edwards only?
No, I think the noise, I'd like
Mr. Oh, right.
And
yes.
And certainly Mr. Peake ought to be involved as well. And I see Sarah there. Do you have something to add, Sarah?
Oh yeah, tēnā tātou. Commissioner Dash. I just wanted to add, we've got some scope around, or Te Koteitanga o Te Atiawa's got some scope around that the actual airport zone in itself, and Puketapu Hapu, who are the Te Atiawa Hapu with mana whenua over the site. So we are, my colleague Casey is speaking to the noise matters tomorrow. But I guess I just was putting my hand up to say we'd be interested in seeing what those conversations would be between the council and the airport. Just given our scope in the airport as a special purpose zone.
All right. Well, I think I'll leave it with the team for Sarah to liaise with Julie, and then if we need to make any decisions about the structure of that, I think if we could receive a proposal about the scope and who might be involved, that would be very helpful. And certainly Ms. Gardner would be in the centre of that as well. So there's some planning witnesses, there's the noise experts, and yes, we're really looking at some advice for us about what's practical, what's in scope, what's recommended, and the classic witness conferencing about whether there's agreement, let's hear that, if there's disagreement, the reasons why on the approach going forward.
Yeah, I can put something like that together, Commissioner. That's no problem.
Thank you.
So that if you don't have anything else, that is that the completion, that's the completion of the airport's case.
Thank you. Nothing else from you, Kit? Okay, thank you. Right, we're now going
Thank
to
you.
come back.
Thank you.
Mr. Scott, thank you very much for your assistance.
Thank you, Chairman.
And all the witnesses, we do appreciate the time and it's a slightly different way of doing things over the Zoom.
Certainly is.
It's, yeah, you certainly don't get the same ability to sort of express yourself as you would otherwise. So I really do appreciate the
Thank
effort
you.
you've made.
Thank you for keeping the progress going.
Thank you. All right, so we're coming back to the defence submission. And is Baverstock, or is there an introduction from you, Ms. Edwards? There we go.
Good afternoon, Commissioners Dash and Commissioner Littlejohn. My name is Karen Baverstock. I'm a Principal Planner and Technical Director at Donkin and Taylor. I have over 20 years of planning experience, and I'm a full member of the NZPI, excuse me. I oversaw the preparation of NZDF's original submission and further submission on this plan review. And my qualifications and experience are set out in my evidence. I hadn't intended to summarise my evidence. I understand that Mr. Humphreys and Ms. Edwards did a reasonably comprehensive overview this morning, but that you had some outstanding questions in relation to, I think, attachments to my evidence. So I'm very happy to respond to those, or just to, I guess, however you see fit.
So just as an introduction, and I don't know how you were briefed, but we will be issuing a minute probably later today requiring that all witnesses coming forward in the plan process that are expert in assigning the code do make themselves available for questions.
Sure.
And we certainly felt in your case you were running the sort of the shotgun with the attached suggested provisions. That I wanted to have a few questions, and I know as an experienced planner, probably Commissioner Littlejohn has some questions about the way you're interpreting the plan for ease of use and matters like that. So we did want to talk to you. So I'll start off and ask my questions. So you have in your paragraph 13 talked about the districts that have included, I would say, my paraphrase, the type of approach that you're recommending for New Plymouth. Are there any other districts that take a different approach, and are there reasons for that you're aware of?
Yes. There's also a couple of districts which have simply decided not to regulate TMTA on the basis they just don't think it warrants a regulatory approach, and that's also set out in that paragraph of my evidence. And Palmerston North City Council also takes a slightly different approach, and that they struggled to accept the separation distance as a basis to manage noise from the use of weapons and explosives. So ultimately they went with, I think they went with the noise standards, which are the second tier to NZDF's approach. So while they still use those same noise standards, they didn't include that first tier of the separation distance.
Okay. And I'm sure that you probably haven't, or you wouldn't have heard that Commissioner Littlejohn does have some questions about the way the plan's set out around particularly around the interaction between matters of discretion and assessment criteria.
Mhm.
I take it your paragraphs 19 and 20, you feel that the plan is notified, has some issues with it, but you're looking even further than the current submission from Defence when you've looked at the plan. Is that the way I've read that?
There's two issues raised in 19 and 20. The first relates to the matters of discretion, and that was certainly outlined in Defence's submission. And the second was also outlined. It's just the way it's structured is difficult to follow. Both the permitted activity rule contains a default activity status and then matters of discretion, but similarly, so does the noise standard also has the default activity status, and it's that kind of duplication which causes some confusion.
Okay, so it's a duplication issue that
Yes.
concerns you. And in 20, the ability to take into account or being signalled that positive effects can be taken into account with RDAs or controlled activities, is that something you think is missing and needs to be added in?
I do think it should be specifically included in the matters of discretion, and I note there's policy support for that within the proposed district plan. One of the policies explicitly refers to positive effects, but also reflecting that in the matter of discretion, I think then implements that policy direction.
And does your proposed provisions, that pulls that through into the provisions?
It does, yes.
Yes, so I wanted to go to there
Okay.
later on, but we'll look at that then. So in your paragraph 25, you talk about where permitted activity noise standards cannot be met, the default activity status is controlled. So what in your experience, what type of permitted activities that Defence does that might not fall within the permitted requirements? Is there a particular type of activity that gets moved through these other plans?
It's very infrequent that those types of activities require consent, that they fall outside of the permitted activity parameters. Possibly Ms. Edwards might be able to expand on my answer, but the thing immediately comes to mind is something like a multi-nation exercise which may occur across the course of a few weeks and move from place to place and involve large numbers of troops. It's that kind of activity which falls outside of those permitted activity parameters. But for the most part, it would be unusual to need to apply for consent for a TMTA.
Okay. Yeah. That was just trying to get a handle on whether you've been involved with the Defence Forces involved in regularly applying for consents. It's not something that I'm aware of happens. No. Okay. So it's helpful. So you're 43. So this again raises this duplication and default matter, and you've got an appendix attachment 2 to the evidence, which I think you seek to explain that. So can you so this is a structural change that you're recommending. I presume that's all within the scope of the Defence Forces submission.
Yes.
Yep. So we'll look at that structural change first. Can you just take us through that and just walk us through what you're suggesting there?
Sure. I've provided two versions in my attachment 1. The first one responds directly to my evidence and effectively tweaks the existing rules to address that duplication. So there's a couple of minor markups where R1 and R4 It's just being more specific about the noise effect standards that actually apply. So under S2, for example, there's a number of standards which apply to different activities. So it's being clear, the reference is to S2 brackets 2.
Yes, I can see that.
And then the next R7 is simply changing those matters of discretion, which is we discussed earlier and again reflected in evidence.
Okay, yes.
Yeah, and then noise R8. This is one of those examples whereby there is a default activity status within the rule, so in the column next to it, and matters of control. However, in the noise standards, there's also a default activity status and matters of control, which don't completely align with the ones there. So you've effectively got 2 default activity statuses and 2 sets of matters of control, which don't completely align. So in the noise standards, I've suggested simply deleting all reference to a default activity status and or matters of control or matters of discretion, and just having them in the permitted activity rule, which is where I consider they belong.
Okay, thank you for that. I understand that.
Right. And then in the second attachment,
So
So
that's
there is-
attachment 2. Yes.
yeah, that's a broader suggested change. The substance of it is exactly the same as attachment 1. So the matters of control, the actual, the way it's applied in the substance of it is exactly the same. It's just set out in what I consider to be a simpler, easier to read manner. So rather than having a number of rules which apply to temporary military training activities, just having the one broad rule and then the activity standards, the specific activity standards, again, are in the one standard, spelt out for fixed noise sources, live firing, etc., use of explosives, mobile noise sources, etc. So just having those standards, and you'll see if you continue down below, are all in the amended standard S2.
Okay, so I can see the reason why that would be quite convenient if you're just looking at
Yes.
temporary. But I'm thinking further, have you thought about if we did adopt that type of approach, whether that's going to get a lot more words and detail to the plan? If that, you know, I think we are thinking about the overall structure of the plan and how the rules are structured.
Yeah. Yes, no, I appreciate, yeah, completely appreciate that. I don't think it does, in that TMTA are quite unique activities, and hence there's a dedicated or bespoke noise standards which have been developed for them. So I don't think that impacts on the remainder of the plan. I think the changes in my attachment 1, though, are kind of basic changes that are required. I don't see that the plan as it's currently structured is, I do think those amendments need to be made. The attachment 2 is then kind of preferable in that it further simplifies.
Okay. Certainly, I appreciate just the thought you put into this, and gives us very clear directions about your thinking. So those are the questions I have. I'll just see whether Commissioner Littlejohn has anything further.
I think you've sort of jumped in, excuse me, to the issue, Mr. Chair. Ms. Baverstock, you're not the first planner who's said to us that some of the structure of these rules is a bit difficult. And I think I might have explained when you weren't here that our current understanding is that the reason we end up with matters of discretion where a permitted activity defaults to restricted discretion is that's because that's the National Planning Standard says, that the rules have to be structured like that. But your point is a slightly different one in that if an activity isn't going to comply with the standards, then what you're saying is that the all relevant matters for discretion as a consequence of that failure to comply with the standard should also be all in the same place.
Absolutely. I think it currently conflates the permitted activity standard and the permitted activity. The planning standards, certainly it belongs next to the permitted activity itself, but not the standard.
Yeah, I mean, we had this conversation a little bit with the council in hearing 2 to some extent around what makes something a prerequisite for the activity to be permitted, and then what are the standards that ought to apply as sort of slightly different creatures. There's a standard for a permitted activity, and then there's the qualification for the permitted activity, and the councils had to go through and say, well, these are the things we want to make sure qualify you to be a permitted activity. And then once you're a permitted activity, then there are these standards that you have to comply with. And then if you don't comply with those standards, they've gone through with restricted discretion, matters of discretion, on the assumption that the failure to comply with the specific standard also defaults to a restricted discretionary activity. And I accept it starts to get a bit cumbersome, but to some extent it's an artifact of the way the plan's been drafted, and because, as I read it, each of the standards are designed and have a different purpose. They're trying to control a specific aspect of an effect. And you may have only sort of looked at the noise chapter, but once you look at all of the other district-wide chapters, you'll see that each of the standards has a slightly different purpose, and hence why there's a logic to the matters of discretion if you don't meet the standard also being focused on that specific purpose, rather than having a really, really long list of matters of discretion right up the front that would apply across every situation of a breach of standard. And we're going to be teasing this out throughout the multiple hearings along this. But if your theorem was something that you considered was necessary for the particular rules you're interested in to be clearer, then presumably a similar exercise ought to be taken with each of the standards that apply to permitted activities and the matters of discretion that would apply if they weren't met. And so there'd have to be a significant sort of restructuring of the plan, wouldn't there?
Yes, I have looked at it just from this particular area, but I can see what you're saying in terms of more broadly the plan. But I do think there's just no way around having to look closely at that, because when I look at these particular rules, there's kind of one rule that might apply in a default, but then there's another, and there's actually, in some instances, there's a third. And so I presume that issue is common to other areas in the plan. So
absolutely.
Yeah.
It's common to second or third generation plans generally when you end up with layers of management. And one of the starting points of this plan is that your activity might trigger multiple rules and you need consent under all of them. Yeah. And it's the most restrictive rule determines your activity status. So I think it's just a consequence of trying to manage multiple resources of varying levels of importance and significance throughout a district and a region. So I don't think we're going to get away from that unless these new these new amendments or new statutes do away with that completely. But I think what you've done gives a very helpful working example of how it could be done. And I guess the question will be as to whether there's an appetite either by us or by the council to sort of to do it to a much more thematic approach across all the other chapters to do that.
Yeah, appreciate.
Yeah, and I think apart from that particular issue, the only one I had a note, your paragraph 28, helicopter landing areas, you've assumed that the absence of the use of helicopters from the TMTA definition means that they're not to be controlled. Do you understand that that's council's intention as well, or have you checked with council about that? Helicopters are not going to be covered in this?
I'd need to go back and look at the section 42A report. It is my understanding, but it's possibly something maybe the council officers could even comment on now, but that was my understanding, that it's for the very intermittent use of an area versus any long-standing use as a permanent helicopter landing area, then that'd be excluded.
Does the council officer want to assure me that helicopters are not covered because they're not intended to be covered?
Yes, that's correct. So the
Excellent.
definition of
All right. Cool. All right. No, that's good. That answers that one for me. And yeah, well, that was it. And thank you for allowing yourself to be questioned. It's the sort of the icing on the expert in a way. And I think that's the point that Commissioner Daish was just getting at.
Sure.
And if an expert is unable to attend, then there's the option as well of pressuring the panel to find out whether there are any questions, because witnesses can be excused if people have read their evidence and they don't have any questions, but it's just a case of asking in advance rather than just not showing up. So thank you for showing up.
Appreciate the opportunity too. So thank you.
Yeah. All right. That's great. Thank you.
Lovely. Thank you.
Thank you very much, Ms. Beverstock.
You muted yourself, Stephen.
All right. That's the conclusion of today's hearing. We are starting again at 9 o'clock with Mr. Holswich for Ngāti Rahiri. And are there any matters anyone would like to raise before we close off for the day? Sounds like we've all had enough. So thank you for your attendance. Thank you, Julie, for all your help. And we'll be online again at 9 o'clock tomorrow morning.
Brilliant.
Bye-bye.